Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Hannah Beer. Hannah is a solicitor in JMW's Employment Law Department. Hello, Hannah.
Hi, Dominic.
So we've seen in the press recently what's been called the Pingdemic. Now, I certainly don't want to make light of it because I know it's a difficult time for employers and employees alike. And latest figures suggest something like 620,000 employees are self-isolating as a result of being pinged. Now, if an employee contacts their employer, what should employers do?
So you're absolutely right. It is a very difficult time for employers and for employees. It's worth employers considering how they will respond to this at the outset. So where an employee has been advised by the NHS Covid-19 app to isolate for the 10 days, the employer is going to need to balance the effect that this is going to have on their staff and the services that can be provided if they are suffering with staff shortages, and supporting the employee to follow that guidance and to isolate. So the first step is to consider the workforce and whether or not they are able to work from home. If that is the case and an employee is able to work from home, the most reasonable option from a health and safety perspective is going to be to allow them to do so for the 10-day period. But then if an employee is not able to work from home, that's where you can come into difficulty where they've been advised to isolate. Obviously, it is different if an employee is being contacted by NHS Track and Trace to isolate, because that is a legal requirement. So in that case, if you were to ask an employee to come into work, you would be asking them to breach the law, which is obviously a different consideration.
And you mentioned that, asking employees to come in may be a breach of the law. So, I mean, what happens in a scenario where an employer is sort of saying, you must come into work?
So if it's a case where an employee has been pinged, as it were, by the COVID-19 app, so they're advised to isolate for 10 days, but it isn't a legal requirement. In that case, the employer will want to consider alternative options first before they ask an employee to return to work. So to comply with their health and safety obligations, that's going to involve carrying out a risk assessment of the workplace in light of that, and potentially consulting with the workforce on that as well. So alternatives to consider, so for example, can they isolate the employee in work from other employees for that period? Can they enforce social distancing for the entire 10-day period? Is there additional PPE that can reduce the risk of transmission, so face coverings, etc.? And ultimately deciding whether it would be reasonable to ask that employee to return to work. Ultimately, employees are under a duty to comply with reasonable directions of their employer, but where an employer has asked an employee to return to work and the employee considers that that is unreasonable, there is potential exposure to claims on the back of a breach of implied trust and confidence, so unfair dismissal claims, potentially whistleblowing claims if they contact, for example, the health and safety executive. So for an employer, any kind of knee-jerk or blanket policy asking an employee to return despite being pinged by the app is likely to be unreasonable. So it's about considering those options and carrying out that risk assessment so that if you are going to ask an employee to return, that you have considered those options initially.
Thank you, Hannah. And I know that one of the sort of most complex areas, or certainly as employers and employees see it, and the politicians have even argued about this as well, Hannah, is pay. What happens regarding pay if somebody can't come in?
So where an employee can't work from home and it's not safe for them to attend the workplace, the legislation that applies to employees who are quarantining due to being contacted by NHS Track and Trace is that they're entitled to SSP, so statutory sick pay. So even if they are not sick, but they are having to isolate for the 10 days, they'd be entitled to the statutory sick pay after the 3 waiting days, as we call them. So although the legislation itself doesn't refer to the app and to being pinged as such, that's likely to be the most sensible approach for an employer to follow, where an employee is having to isolate as a result of being pinged.
Thank you very much for your insight, Hannah. And as is always the case with these sorts of things, you know, sometimes bespoke advice is what is required. And of course, you know, employers can get that from you as well. If you'd like to contact Hannah, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.